Seches Bava Kamma Daf Ayin contains one Mishnah. Briefly before the Mishnah, the Gemara brings a number of halachos about a harsha, about giving someone a power of attorney, some of which are based on our last sugya of Rav Yechanan, and then we'll get to our next Mishnah, which goes back to the halachos of paying a kefel dalid vehe. So let's see the Gemara. The Gemara begins with the two halachos said by the Nahardoi, people of Naharda. So first of all, they said that we don't write a power of attorney to collect property, one, in a court case if the property is movable objects. What this means is that if Reuven has a court case against Shimon, he says Shimon was a shamer for him, he's holding on to something and he wants it back, and the court says that Reuven does have claim and he gets it back, they cannot write a power of attorney to a third party to be a shliach to go and get it away from Shimon. Let's say to authorize Levi to be a shliach to come take it from Shimon and give it to Reuven. You can't do that because you can't transfer possession, you can't transfer power over the object from Reuven, even if he's a rightful owner. He can't transfer his power to Levi because he doesn't have possession. Although he might be the rightful owner, he doesn't have possession. The possession is by Shimon, and that's based on Rav Yechanan's last halacha that you can't transfer ownership of anything unless you have both ownership and possession. Now, says the Gemara, there's two versions of this. This is the first version. The second version is that we only said this halacha if Shimon actually denies it. So Reuven says, you owe it to me, it's my thing. Shimon says, no. Here, you can't give over a power of attorney because it looks like a lie. Reuven's giving over power of attorney over something there's a court case over it. Shimon says it's not yours at all. So it looks like that whole power of attorney is fake. However, if it would be established that Shimon has to give it to him, then he would be able to go collect from it. And the power of attorney is valid when Reuven gives the power of attorney to collect it to Levi. Now, says the Gemara, another halacha of the Nahardoi, this power of attorney, and whenever you do write it validly, has to say in it, go and litigate on my behalf and collect it from him for yourself. It has to go say in it, take it for yourself. And you're trusting that the power that the attorney is going to give it to the original owner, even though it says in it that it's for himself. And the reason is because otherwise, when he comes to take Shimon to court, and he comes to try to take it away from Shimon, Shimon will say, who are you? You have nothing to do with this. This is between Reuven and I. You're claiming that you have a right to it. Prove it. It's not relevant to you at all. So therefore, he has to pull out a document that says, no, I'm going to get it if I take it from you. And therefore, he does have to deal with him directly because if Reuven wins, then Levi has the right to actually collect it. Now, says Abaye, it doesn't have to be that he has full rights to it. It could just be his partial. You can say that he gets a half, a third, or a fourth of the property, since, therefore, he does have a handhold in this object. Shimon has to deal with him. He can't say he has nothing to do with you. And since he has to deal with him already, he has to deal with him as far as the entire case. Now, says Amimar, what if Levi then decides to stab Reuven in the back and say, you know what, I'm keeping it for myself. I'm not going to give it to you. So Amimar says, then he wins because he has it. So therefore it says he doesn't have to give it back. Says Rav Ashi, no, since the document says that I'm going to court for you and everything that you will win, I'm giving you, clearly he's a shliach. So the different version is not that he's a shliach, but he's a partner. So he's a messenger, he's a partner. And therefore he can't keep it for himself because the document itself shows that he's not the rightful owner. Says what's the difference between the term shliach and partner, shliach and shutef, as far as this is concerned? So it says that would depend on, the difference would be if he claims half of it. If he grabs half of it and says, I'm holding on to this half. So if it says partner, so then the document supports his claim, whether it's true or not, the document supports the claim. If it says shliach, and he claims he gets half, so there's no validity to that, and therefore he would lose the entire thing. The Gemara says the halacha is that it's shliach. We now begin the Mishnah, which discusses the halachas of paying dalad vehe. So again, you pay 4 or 5 times the value of a sheep or a cow when you stole it, and you then proceeded to either sell it or slaughter it. Now, you have to establish that it was stolen and that you sold it or slaughtered it. It also has to be that by slaughtering it or doing something else, it's a real shchita, it's halachic shchita or sale, and it also has to be that you're not getting some other einish which would override this dalad vehe with kamei v'deramine. So the Mishnah brings a list of, first it speaks about how you can establish the truth of it, and then it talks about a list of cases where you may think you don't have to pay dalad vehe, but really you do. So the Mishnah begins by saying that if you have 2 witnesses that he stole it, and then either the same 2 or 2 other witnesses to establish that he sold it or slaughtered it, there you've established everything, and you have to pay 4 or 5 times the amount. Now, if he stole it and sold it on Shabbos, And here we have the list. He stole on Shabbos. He still has to pay the dalad v'hei. He's not chayiv misa for that. There is no chil Shabbos deraisa. That as opposed to, the Mishnah doesn't say, but as opposed to, if he stole and slaughtered on Shabbos, that would be a malacha and would be chayiv for that, and therefore he wouldn't pay the dalad v'hei. If he stole and sold it for an avodah zarah, so he sold it to avodah zarah, he's not over avodah zarah, he still has to pay dalad v'hei. If he stole it and slaughtered it on Yom Kippur, so Yom Kippur he gets kares, not misa, and therefore he still has to pay the dalad v'hei. Stole his father's, slaughtered it and sold it, and then the father died and he inherited it, you still have to pay the dalad v'hei because he inherited it after he was chayiv the dalad v'hei. If he stole it, slaughtered it, and then was makdish it, again the hektish comes later after his chayiv, so he still has to pay the dalad v'hei. Next, if he stole it and slaughtered it as a refuah for some cure or to feed the dogs, that's still all valid. He has to pay the dalad v'hei. Then we have two cases out of machlekes. If he stole it and slaughtered it, and it turned out that it was a treifa, or he slaughtered it as chulin in the azara, non-carbon in the Beis HaMikdash. So there, Tana Kamma says you still pay the dalad v'hei because it's still a shchita. And Shimon says it's pater because these are not valid shchitas. These are shchitas that you can't eat. These are shchitas that are invalid, and therefore it's pater from the dalad v'hei. Dalad v'hei is only when there's a valid shchita. Now we get the Gemara. The Gemara's first sugya is the halacha that the Mishnah said that you could have different pair of edim, one pair of edim saying that he stole it, and a different pair of edim saying that he slaughtered it. So Gemara says the fact that you could have two different pairs for each part of his obligation to pay 4 and 5, that does not go like Rabbi Kiva. Rabbi Kiva says it has to be the same pair that establishes everything to be mechayiv him. And that's Rabbi Akiva's drasha, where it says, davar, on two witnesses, a thing will stand, a thing, not half a thing. You can't have half a thing. You can't have a pair of witnesses establishing half what you need, that he stole it, and a pair of witnesses establishing half a thing, that he slaughtered it. Each of those is only a half, and therefore it's useless. Now, where do you see Rabbi Akiva saying this halacha of davar v'lei chati davar? Someone quotes a brisa, that Rabbi Yosi and Abba Chalafta, that Rabbi Yosi said that Abba Chalafta was his father, went with Rabbi Yochanan ben Nuri to learn. So there's two versions. Either Rabbi Yochanan ben Nuri went to learn by Abba Chalafta, or Abba Chalafta went to learn by Rabbi Yochanan ben Nuri. Either way, when they went to learn with each other, they discussed a situation where someone was trying to prove a cheskas habatim. He was trying to prove a cheskas gemel shanim. They lived in the house for 3 years. And that would establish ownership if somebody wants to claim that it's not his. But each of the 3 years, he has a different pair of witnesses. One pair for the first year, a different pair for the second year, a different pair for the third year. So what is halacha? Does that establish or not? That's a question that they discussed, and whoever it was who answered, he said, yes, it is a chazaka. And the first one said, I agree, but Rabbi Kiva says otherwise. Rabbi Kiva says that this would be davar v'lei chati davar, because you have each year is worthless, and each pair of witnesses is saying a worthless piece of information until you put it all together, and that's no good. So here also you have each pair of witnesses is saying worthless information, and that's no good. So on that, Abai responds, Abai says, no, you're right, the one who testifies that he slaughtered it is useless without the other one, because slaughtering doesn't have any validity. There's no halacha based on that. But the one who says, the pair of Edom that says that he stole it, that's a thing. That's a valid testimony. That's mechayvin to pay kefil at least. So therefore, that's a valid testimony that's accepting. And then the second pair can come and piggyback on that. And therefore, there is, since the first pair can stand on its own and establish something significant, it's not a chatzi davar, and the one who adds on to it is also not a chatzi davar, and therefore, Rabbi Kiva would agree in this situation. The Gemara says this is similar to another place where we saw Rabbi Kiva agreed, and that's where he was discussing where we wanted to be mechayev someone misa for having bia with an eshes ish. So we had two sets of edim required. First of all, that she's an eshes ish, that she got married, she had kiddushin, and second of all, that the bia happened. So the witnesses that testify that the kiddushin occurred, that's a valid testimony. It creates a situation that she's married. There is a significance to that, and therefore those don't require the edei bia. However, the edei bia are worthless without the edei kiddushin. But since the edei kiddushin have a validity and establish something significant without the edei bia, it's not called chatzi davar, and therefore it's good. Now, the Gemara says the Rabbanan, who we said argue on Rabbi Akiva, and they don't have this drasha of davar v'lei chatzi davar. What is that pasuk for, according to them? So the Gemara says that is to teach us that you can't establish half the fact. Not that you can't establish one of the two facts that are needed, but you can't establish half a fact. So, for example, if we're trying to prove that a woman is a gedola, by which, since we have to prove that she has two hairs. So if one pair of witnesses see one hair on the back and another pair see one hair on the front, each one didn't see anything because each one just saw one hair. It's only until you put them together that there's a significance there. So that's not one out of two things that you need to establish. That's half of what you need to establish. That's no good. Now, the way the Gemara first expresses it is that you had one witness who saw one hair on the front and one witness saw one hair on the back. The Gemara says that one witness, that's nothing because that's half a testimony. You need two to testify, not just one. So therefore, that's not the case. And therefore, the Gemara adjusts it to you have a pair seeing each hair. You can't put the two together to establish that she is a Yedayla. The Gemara now moves on to the next part of the Mishnah where we had seen that if somebody steals it and he sells it on Shabbos, he still has to pay Dalad V'Hei, meaning that he's not Machal Shabbos D'Oraisa, he's not Mischayev B'Nafsho, and therefore there's no Kimli B'Deramine. Gemara asks there's a contradiction in this Brisa that says that he's Potter. So that Brisa is saying that there is a Chil Shabbos D'Oraisa. So the Gemara wants to know, it's a contradiction between the two. Gemara says that Brisa that says he's Potter is talking about a situation where the sale violated Shabbos D'Oraisa in some other way at the same time. The concept of sale, the act of sale itself doesn't violate, but the act of sale was done in a way that violates. And therefore he's Chayev B'Nafshay, he's Chayev Misa for that, and therefore he doesn't have to pay the Dal V'Hei. Now, what's the case? So the Gemara's first attempt is Bava Kamma. Bava Kamma says that the purchaser said to the seller, who's also the thief, he said, pick some figs from my tree, and by you picking the figs, you will be makneh the animal to me. Meaning the sale was in effect when he picked figs off a tree on Shabbos. Picking figs off a tree is an Isser D'Oraisa of Chil Shabbos, and there was some Chayev B'Nafshay, and he doesn't have to pay the Dal V'Hei. So the Gemara has a question on this, that in a case like that, the sale is actually not valid. Because since he's Chayev B'Nafshay by the sale can't go through, and if the person comes to collect the animal, he can't. If he goes to court to say, give me back my figs or give me the animal, he won't get either of them, because it's invalid because it's Chayev B'Nafshay in the same instant. So therefore, since the sale is invalid, he doesn't have to pay Dal V'Hei for that. So that can't be the case of the Brisa. So the Gemara goes to another case, and this is brought by Rav Papa, who he said, throw it to me. Throw what you stole to me into my chatzar. And when it enters the chatzar, so that is when he's kainit. That's when the sale goes into effect. And there it goes into effect. Obviously, it's valid because he's a kainit. But by passing it from the Rosh Hashanah into the chatzar, it is Chil Shabbos of Hitzah. So the Gemara points out, maybe this only fits in Rabbi Akiva's opinion, because Rabbi Akiva holds that when something passes into the airspace over the chatzar, it's considered to be like it's already on the ground, and there's already a hanacha, the thing has already come to rest, and you're already chayev Chil Shabbos. You have to say that, because from the moment it passes into the airspace of the chatzar, he's already kaina it, so the kinyan happens when it crosses into the airspace. If the Chil Shabbos only happens when it lands, and the Chil Shabbos is later. So he would be chayev the Dal V'Hei. He wouldn't be able to say Kimli B'Deramine on that. So, do you have the Kimli B'Deramine? It's got to be according to Rabbi Akiva that he's Mechal Shabbos as soon as it passes into the airspace. So the Gemara says not necessarily. Could be a case where he made a condition and he said that I'm not going to be clean it until it lands. So therefore, when it lands, it's both things. The Kinyan's Chalka is obviously a condition that he made, and he's Mechayev B'Nafshay, even if you don't hold like Rabbi Akiva, that when it passes into the airspace, he's already considered to be like it's on the ground. Now, says Rava, I can defend Rava B'Chamas Pshat, and I'll tell you that even though it's not collectible, even in the case where he picked figs, and that sealed the deal, and that's Chil Shabbos. And in that case, the buyer can't come collect. If he comes to collect, we'll tell him, no, this guy's Chayav Misa for what he did. You can't collect, not the figs back and not the animal. Still, it's a valid sale. We may not let him collect, but the sale is valid anyway. And therefore, he has to pay the Dalad V'Hei. Now, where do you see something like that? That has the halachic concept of the sale is valid as far as being Mechayev the Dalad V'Hei, even though you can't collect. So where it says, I'll show you in the case of an Esnan Zaina. The halacha is that if somebody pays a zayna with an animal, that animal is possible to go on the mizbeach. It's mias, you can't use that on the mizbeach. That's true even if the bezin won't be mechayev him to pay. So let's say he was mechayev b'nafshay with that same maisa's nus. Let's say he hired as a zayna, he hired his own mother, and then that maisa bias mechayev him misa. But if she comes to collect her esnan, we're not going to make him pay that because he's mechayev benafshe for that. Still, that sheep that he promised her will be usher. It's still an esnan zayna. If he not that he promised, if he actually gives it to her, it's still an esnan zayna. So the concept of esnan zayna is chal on it, even though up he didn't, we couldn't be mechayev. In this case, also the concept of the sale is chal, and the din sold is chal, and therefore is chayav al v'hei. That is all chal, even though the courts would not have enforced it.